Good morning, friends. I am talking about behaviors of the advocate on court case law that belongs to 2010, and its contents might not be applicable or explain the today's behavior. So I am sorry for that. Uh, I am going into the case law that is Poonam versus Sumit Tanwar, that is of 2010. Friends, this case was heard by Honorable Justice B.H. Chauhan and Aftab Alam of our Supreme Court of India. In this case, the relevant sections involved are 13B, subclause 1 and 2 of the Hindu Marriage Act. If you want to go more details into this case, you can go to equivalent citation, that is Manu SC 0187 of 2010. Friends, in this case, very interesting stories therein, which I am going to share with you in the form of facts of this case. The facts and circumstances giving rise to the present case are petitioner and respondent got married according to Hindu rites in Delhi. They separated just after 2 days of their marriage. A petition for resolution of marriage by consent was filed under Section 13B, subclause 1 of the Hindu Marriage Act 1955. The family court was of Delhi and it accepted the said application, which was later on titled as Poonam versus Sumit Tanwar. The court observed that in view of the Section 13B, subclause 2 of the Hindu Marriage Act, the marriage between the parties cannot be dissolved straight way. So, as per the statutory provision, parties were advised to make further efforts for reconciliation in order to save their marriage. In case they are unable to do so, the parties may come up with petition of second motion that is covered under Section 13B, subclause 2 of the Hindu Marriage Act. So, the Honorable Court of Delhi allowed this first petition, first motion, that is, was presented under Section 131B of the Hindu Marriage Act, with the direction to come later on, after statutory period of 6 months, for second motion. The party was aggrieved by the order of the family court. So they filed this writ petition in the Supreme Court. When the matter came up for preliminary hearing, Mr. A, we can say proxy counsel, was not able to explain under what circumstances this writ under Article 32 of the Constitution is maintainable for a relief as desired in the petition. And it further inquired whether the court has the power to issue a writ to the court or tribunal to violate the mandatory statutory provision. So, friends, the learned counsel was not able to explain under what circumstances this writ petition lies. And further question were, who are the necessary parties in writ petition? So he was not able, the proxy counsel was not able to argue the matter properly before the court. The matter was passed over, and the proxy counsel was directed to come along with Mr. B, who was advocate on record and who had signed the and filed the petition. So now there is second round when the matter again came up for hearing. Now again another proxy counsel appeared and he introduced himself as brother of Mr. B, who is the advocate on record. The second proxy counsel also expressed his inability to satisfy the court, or we can say to render any assistance to the court on the legal issue involved in the petition. So, friends, being faced with an inordinary and unfortunate situation, the Honorable Court of the country and the appearing counsel for this case was not able to render any assistance. The matter was again adjourned with the directions that the learned advocate on court, that is Mr. V, should appear in the court. After two proxies, Mr. B, learned advocate on record, appeared in the court and he could not furnish any explanation whatsoever to defend his petition, nor he could explain how this petition is maintainable under Article 32. Realizing his mistake, he tendered absolute and unconditional apology and further assured the Honorable Court that he will not lend his name merely for filing the petition by other counsels in future. So, friends, while going through this petition, the main issue was at that time, not now, that the few of the advocates are signing the petitions just for namesake, and they are destroying the very noble system which is created in the name of advocate on record to assist the court properly. Honorable Court dismissed the appeal. While dismissing the appeal, it take into consider one important case which was already decided, that is Vijay Dhanji Chaudhary versus Suhas Jayant Natwadkar, and citation is Manu SC 1807 of 2009, and second one is 2010 1 SCC 166. In this case, the Honorable Court has taken note of the ongoing rampant unethical practice by some of the advocates on court, not all the advocates, by some of the advocates on court, who were duly enrolled under the provisions of the Supreme Court Rule 1966. So, friends, many especially petitions were being filed by them merely as a name lender, without having or taking any responsibility for the case. So, in that situation, as a result of prevalence of such a practice in such cases, The advocate on record did not appear when matters were listed before the court, nor did they take any interest or responsibility for processing or conducting the case. They also played no role in preparation of the petition, nor ensured that requirement of rules are fulfilled, and they were not attending the defects which are pointed out by the registry to cure them in time. Our court observed that if the role of an advocate or court is merely to lend his name for filing cases without being responsible for the conduct of the case, the very purpose of having the system of advocate or court would get defeated. So, in this case, the court did not merely dismiss the petition for not rendering any assistance by the appealing counsel in absence of advocate or court, rather issued notice to the Supreme Court Bar Association and Advocate on Court Association asking for suggestions for improving the system and to compel such mere name lending advocates or court to serve the purpose for which they have been enrolled. So that matter went into many rounds after the associations submitted their suggestion how to control observation and strict adherence to rules. Now coming, friends, in this case, if we go by the application for dissolution of marriage, which was filed before the family court, and said application was disposed of, asking the party to wait for 6 months. So this is not the case there that there has been any delay in disposal of the case by the family court. This petition has been filed without any sense of responsibility, either by the parties or their counsel. So this type of practice is tantamount to not only disservice to the institution, but it also adversely affects the administration of justice. So the conduct of all of the parties involved in this episode has been reprehensible. So with this observation, that petition was dismissed at that time. I am, friends, again saying that I am not talking about this time atmosphere. This is the petition which may come into the, while replying to professional ethics of the advocates in advocate on examination. That why I am taking the past decided cases to make you comfortable. That's all. God bless you all. See you again. Thank you for watching. Friends, if you find that there should be any improvement in my videos, do feel free to criticize my videos. I will be happy. Thank you for watching my video. Don't forget to share, subscribe, and like if you feel it is worth liking.